Hello, everyone, and good afternoon. Thank you for joining Foley for today's Labor and Employment webinar. Today, we will discuss the key California employment laws that are scheduled to take effect on January 1st, 2020. Before we get started on today's presentation, I'd like to go over a few housekeeping items. For those of you that may have questions about any of today's topics, we invite you to type them into the Q&A widget on your screen. We will try our best to answer all questions at the end, time permitting. However, if we do not get to all of your questions today, we will be sure to follow up with you via email. A copy of today's slides are available in the resource list widget, and a recorded version of this presentation will be available on Foley.com in the next couple of days. For those of you that are seeking CLE credit today, to be eligible, you must be logged on for the full duration of the webinar, and you must enter a 5-digit code when it is announced later on in the presentation. For those who are seeking HRCI credit today, please enter your name when prompted later on in the presentation. CLE and HRCI certificates will be distributed via email approximately 8 weeks after the webinar. Please note that if you are seeking Kansas, New York, or New Jersey CLE credit, you must also fill out the Attorney Affirmation Form, which is located in the Resource List widget. If you experience any technical difficulties with the webinar platform, please refresh your browser or see the webcast help guide on the bottom of your screen. And as a final note, a short survey will appear on your screen. We would appreciate it if you provided us with feedback on today's webinar to help us improve our webinars in the future. And now I will turn it over to Krista Cabrera to introduce our presenters.
Hi, good morning, good afternoon. Thanks so much for joining our webinar. We're really excited to present to you all about the fun California laws coming down the pike next month already. You have today our sort of core California labor and employment group, and that consists of Kamran Mirrafati. Kamran's a partner in our Los Angeles office. Myself, I am a partner in our San Diego office. Kaleb Berhe, who is a associate, fairly new to us. We're really happy to have him on board in our Los Angeles office. And Kristina Fernandez, Mabrie, who is an associate in our Los Angeles office. And throughout the presentation today, you will hear from all of us. So we decided we'd start with a bang. I know that AB 5 is probably the main reason many of you are here. This is the statute that takes effect January 1st, 2020, that has really rocked California businesses and the gig economy in particular. So let's sort of start with how this happened. How did we get here with AB 5? Back in 2018, back like it was so long ago, last year, the California Supreme Court issued a real shocking opinion when it held that, and this was the Dynamics case, which many of you are probably familiar with, it held that the Borrello test, which was a test that had been established long ago by a case called Borrello, that was a multi-factor, very flexible test where no one factor was determinative and where the worker alleging misclassification had the burden of proof, was the proper test to use to determine whether a worker was an independent contractor or an employee. And that test, which we'd all become really familiar with and used for years, looked at things like, does the worker use his or her own equipment and tools? Does the worker work for other companies and not just this company? Huge, long list of factors. And it was really sort of a mushy, gray test where, quite often you could really justify having a worker classified as an independent contractor, even if, the person didn't meet every single factor, it didn't matter. Again, there was no one determinative factor. And at the end of the day, it really just boiled down to control, like how much control is the company exerting over this worker. So the California Supreme Court in 2018 in Dynamics said that is the wrong test to use for claims that are brought under California's wage orders. And our wage orders, unlike our labor code, really apply more to non-exempt than to exempt employees. The wage orders cover things like rest breaks, meal breaks, overtime. So we were left after this case with this strange scenario where a test for claims brought under the wage orders was going to be totally different than the test for claims brought under the California Labor Code, often in the same lawsuit. But in any event, the test that Dynamics established is what has been come to be known as the ABC test. And under that test, first and foremost, the burden of proof shifted. It is no longer the worker's obligation to prove that he or she was misclassified in order to pursue a lawsuit for independent contractor misclassification. Under the ABC test, it is the company's burden to prove that the person was correctly classified. Let's see. So next, the first prong, A, the company, with now the burden, must establish that the worker is free from control and direction. That's pretty much what I was just talking about with the Borello test. Not a huge change. Most companies using independent contractors are going to be able to meet Part A. But with this test, unlike Borello, all three factors must be met for the person to be an independent contractor, not just one or two, all three. So next, and this is where most companies have quite a bit of trouble, B, the worker must perform work that is outside the usual course of the company's business. And what the Dynamics Court said about that is, here's an example of a person appropriately deemed an independent contractor. A retail store hires a plumber to fix a toilet. That person is not doing work that is, part of the retail store's normal business, selling clothes or whatever. Truly an independent contractor. Now, another example the court gave of a case where the person would be misclassified is a bakery hiring a cake decorator. Even if that person can decorate cakes whenever they want, even if they can decorate cakes in their own home, even if they work for 30 other companies, that's the core business of the company. That cake decorator should be an employee. And then C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So our plumber, to stick with that example, is a plumber. That's all he does. He's just fixing toilets all day long. He's a plumber. He's not fixing a toilet and then an hour later, selling clothes somewhere else. So obviously this is a very tricky test. It's quite difficult to meet, but we weren't super concerned because, again, it only applied to the wage orders. Well, then AB5 came along and codified the new test, the Dynamics test, and said, guess what? It applies to the labor code as well as the wage orders, same test. So now we have got the ABC test all throughout the state of California for any company who wants to use independent contractors. You must be able to establish A, B, and C all are met, and the burden of proof is on the company. Now, there are some exemptions written into the law, and I keep hearing that there are industries actively lobbying for more exemptions. So here is a list of what we have now in terms of exemptions, and it's really important to know. If you have people working for your company as independent contractors who meet one of these exemptions, it doesn't mean they're automatically correctly classified. It just means the old Borello test applies, not the new ABC test. So you still need to be sure that these people are truly independent contractors, but it's just under a less stringent test. So we have here on the list so far physicians, dentists, podiatrists, veterinarians, so, healthcare industry. And I have heard that there is lobbying to expand that piece because, it doesn't cover a lot of professions in the healthcare industry that many believe should be covered, like RNs, like PAs. So I know there is work towards adding some more exemptions there. To sort of your traditional professions, lawyers, architects, engineers, and accountants. And again, I really want to note this. I've done several audits of companies that employ engineers. Not all engineers are exempt under the old test. So all this is saying is apply the old test, not that you're automatically home free. 3 deals with broker-dealers and investment advisors. 4 deals with salespeople. 5 fishermen, commercial fishermen. 6 deals with the real estate business, repossession agents, estheticians, electrologists, manicurists, barbers, and cosmetologists. 7 deals with the contracting industry and motor club service providers. 8 deals with a sort of catch-all slew: travel agents, HR administrators, marketing directors, grant writers, fine artists, payment processing agents, freelance writers, cartoonists, and editors who are able to meet certain other requirements outlined in the bill. And then 9 is the final very specific exemption they've included, which deals with, again, sort of a real catch-all, everything from graphic designers to dog walkers and groomers.
So I'll follow up. This is Kamran Mirrafati. I'm going to follow up on Krista's great explanation of AB 5 and try to give some practical guidance on how to address this issue. Unfortunately, because the exemptions are somewhat narrow, many California employers are going to have to re-examine their contractors and potentially have to reclassify these individuals as employees, unless you fall within one of the exemptions that Krista mentioned. But even then, you would have to just reassess whether the Barela factors are being met. So even though you could try to update your independent contractor agreement to minimize the risk, it's not necessarily going to avoid the risk altogether because the agreement alone is not sufficient to avoid the risk. The courts are likely to look at what is actually happening behind the agreement, whether the worker is actually meeting the test, the ABC test directly rather than what is mentioned in the agreement. So you could try to mention that you're meeting the requirements of AB 5 in your written agreement with a contractor, but if that is actually not happening in practice, then there would still be potential liability. The other issue to consider is that even agreements with your vendors, with a legitimate third-party business, could potentially still be at risk. If that vendor is using independent contractors and those individuals are not being properly classified, it's possible that your business who is contracting with that vendor could now be liable for any liability associated with your use of that vendor misclassifying those workers. Almost like a joint employer theory, because the AB 5 could allow the workers that are working for that vendor to come after your business who is contracting with that vendor. And even if you have a legitimate vendor situation where that vendor is properly classifying their workers as independent contractors, if those contractors were properly classified under the ABC test from that vendor's perspective, if those vendors are performing services directly to your customers and in connection with work that is related to your business, it is possible that the ABC test would still not be met even under that scenario. So you really need to reassess all the agreements with vendors to make sure ABC test is being fully met. The other thing to consider is that Dynamex and also portions of AB 5 could be deemed retroactive. The issue has been litigated already a few times, and there was a Ninth Circuit decision that came out that indicated it was retroactive. but then that decision has now been put into the hands of the California Supreme Court. And based on past decisions from the California Supreme Court, we believe that the Dynamex case could be deemed retroactive, which creates other risks because under AB5, if you are planning to reclassify some of your workers in accordance with AB5, and that's one option, is the least risky option is to reclassify independent contractors as employees. If you do that, which is the right move to do potentially if there's risk under AB5, there's also the possibility of those individuals then bringing a claim against your company for prior misclassification under the prior Dynamex case, because Dynamex would be deemed retroactive. So you have risk no matter what you do. Unfortunately, we could help manage those risks for you, but there's no matter what is done, unfortunately, it could result in potential liability for a business in California. Another option could be to try to reconfigure your operations as a business in order to minimize liability under AB5. And the way you would do that is the hardest part of the ABC test to meet is the portion that relates to the B part of the test, which is the contractor performing services that are directly related to your operations. You could try to argue that your operations are different now, that you're changing your operations to have a different business goal or business perspective, and that the contractor is no longer performing those same services that are related to your business. This is an argument that a lot of the app-based service companies have tried to use, Uber, Lyft, Grubhub. They've tried to raise the argument that they are a tech platform and that they have that the contractors performing the services are not related to their main purpose of their business. That issue is likely to be litigated. Who knows if it's going to work, but it is an option, and many clients are trying to take that approach. We believe it's risky and it may not work, but it is an option that many clients are considering. The most risky option, and if it could apply even to your business, is that there is a potential ballot initiative being created for app-based services, and in order to see if the California legislature would overturn AB5 for app-based services. Uber, Lyft, and Grubhub have been lobbying to get this ballot initiative, and if it passes, then there could be an exception created on AB5 for app-based services, things like Grubhub, Lyft, and Uber, for instance. So some clients could potentially want to wait out to see what happens with this ballot initiative. So moving on to another major piece of legislation, the California Consumer Privacy Act, or CCPA. This technically came out in 2018, but it is now being effective as of 2020 for the most part. For the majority of the decision of this legislation is going to be effective 2020. There has been an exception created for employees, which we'll get into. But for the most part, the requirements of this law it's a new privacy act that was created, and when California became the first state to have this consumer privacy law created. It's similar to the European law on this issue, the GDPR. And when the CCPA actually becomes effective, entities doing business in California will have to have new data protection duties, and California consumers will have new rights regarding their personal information, including being able to ask a business to delete their information, and if there's a breach of their information, they could bring a private right of action for penalties and damages. So this only applies if your organization does business in California and meets the following thresholds. You have to have more than $25 million in gross revenue annually. And those gross revenues are not limited to only California. It could be anywhere. So long as you pay California taxes and you have over $25 million in revenue, then the entire provisions of the CCPA will apply. Another way, if you have less than $25 million in revenue, it could apply if you either process or collect personal information for more than 50,000 California consumers, households, or devices per year. And lastly, if you have 50% or more of your annual revenues derived from selling personal information, then the CCPA will also apply. So the good news for most of the people on this webinar is that the employment data at issue under the CCPA is technically not effective until January 1, 2021, so not this coming year, but the following year. There was some lobbying done to move the employment information to another year to extend that deadline because there was so much, there was not clear as to how to deal with employment information. So they have agreed to delay that requirement until the following year. But based on the regulations that just came out a month ago, there is still a privacy addendum that is needed to be implemented for all California employers as of January 1, 2020, this coming year. We can help you prepare that privacy addendum. It's basically a 2 to 3 page addendum that could be added into your employee handbook that explains to employees what information is collected on them. And so technically, while the CCPA would allow consumers to be able to ask you to delete their information, that portion of the CCPA does not yet apply because it's not practical for an employer to be asked to delete the information of the employee. But you are required to at least give information to your employees about what information is collected on them based on the current law, which is going to be effective in 2020. We'll move on to the next one, which Kristina can address.
Hi, everyone. Kristina here. So AB 51 is the new law in California which limits mandatory arbitration agreements. It was signed into law on October 13th, and it will take effect on January 1st, 2020. The law is pretty expansive, but as I will discuss in a bit, it will likely be short-lived. What does it do? So AB 51 prohibits employers from requiring applicants or employees to waive any right, form, or procedure established by the California Fair Employment and Housing Act and the California Labor Code. It applies to contracts for employment entered into, modified, or extended on or after January 1st, 2020. And it basically makes it so that any agreement in an employee contract that requires an employee to opt out or take affirmative action in order to preserve their rights is prohibited. But what we think is going to happen is likely there's some preemption that might apply. Generally, the Federal Arbitration Act, which is 9 U.S.C. Section 1, the FAA preempts state laws like AB 51 that attempt to regulate and or restrict arbitration agreements more strictly than other types of contracts. And the U.S. Supreme Court recently issued a decision that upheld the validity of the FAA. So it's likely that AB 51 might be challenged and could be found constitutionally invalid under the recent Supreme Court case and also FAA. But on the other side of that, AB 51 expressly states that it does not invalidate a written arbitration agreement that is otherwise enforceable under the FAA. So based on that statutory language, even though it's untested in California, the impact is essentially a savings clause, and it could be difficult to predict what the effect of that savings clause is at that time. Other questions also remain unanswered. For example, does the current agreement extend into 2020 if it's not abrogated by the parties prior to January 1st? So what are the effects of agreements that are signed right now in this time period before January 1st, 2020. Again, we anticipate some kind of legal challenge on AB 51 on the grounds of preemption, which could eventually lead to the invalidation of the law. So what should you do with your arbitration clauses in the wake of AB 51? If your arbitration clauses are left unchanged, employers should note that there's a risk of the violation of the new law, which is in itself a misdemeanor under AB 51, and you might consider modifying the language of your agreement to utilize either the opt-in or opt-out language, but these options are also imperfect in the wake of the statute. So that leaves us with whether or not arbitration agreements are in the best interest of California employers any longer. There's pros and cons of arbitration agreements. The cons are obviously arbitrator fees can rack up pretty quickly. Arbitration is no longer the cheap option. We have some cases in arbitration right now, and the fees per hour can be in the thousands, and you can have a multi-day arbitration, which is into the six figures, just based on the arbitration fees alone. Also, arbitrators are less likely to grant motions for summary judgment or adjudication than state court or federal court judges. On the other hand, there's confidentiality that's available in arbitration that is not available in a state or federal forum. You can avoid the very high jury awards that are common in California. So it could limit the recovery that a plaintiff might avail themselves to. The biggest advantage of arbitration is obviously the class action waiver, but even that benefit has watered down a bit because of PAGA. PAGA actions are much more difficult to defend than a regular class action, so it's possible that an arbitration clause could increase the chance of a PAGA action in lieu of the class action. The next one we have is SB 188, which is hairstyle discrimination. This law basically codifies other case law that already exists. Basically, it expands the definition of race for purposes of the FEHAT to include traits historically associated with race, including but not limited to hair texture and protective hairstyles such as braids, locks, and twists. So under SB 188, employers cannot enforce grooming policies that are facially race neutral to discriminate against those with natural hairstyles or protective hairstyles. The rationale behind this being that workplace dress codes and grooming policies that prohibit certain hairstyles have a disparate impact on certain races and may be a proxy for racial discrimination. So our advice on this one is to review your employee handbook, make sure that your dress code and grooming policies don't reference kinds of hairstyles or, have anything that might be in violation of SB 188. And I will pass it on to Kaleb.
Hi, everyone. So I'm going to take you through the recent ban on rehire clause, no rehire clauses. Everyone knows these, they're ubiquitous at this point in settlement agreements, but now the state of California has essentially banned them in certain circumstances we're going to outline in a second. So for a general overview of the law now bans settlement agreements from containing provisions that prohibit, prevent, or otherwise restrict future employment. This is limited to aggrieved persons. That's important because the definition of aggrieved person under the new law is a person who has filed a claim against the person's employer in court before an administrative agency, in an alternative dispute resolution forum, or through the employer's internal complaint process. What does this mean? This basically means that there's a potentially strong argument that could be made that no rehire provisions are still fair game in severance agreements or settlement agreements that are negotiated in response to demand letters or unfiled claims that don't fall into one of these enumerated categories that are defined under the aggrieved employee under the new law. So it's important to remember that while this is not great news, there is some hope, there is some light at the end of the tunnel. If you're in a situation that involves an employee who doesn't have a claim before an administrative agency or an alternative dispute resolution forum or through an internal complaint process, then you still are okay to use these no rehire clauses in your settlement and severance agreements. Another important thing to note is that this only applies to settlement agreements entered on or after January 1st, 2020. So if you are on the cusp of entering into a settlement agreement with an active dispute right now, this would be the time to do it before the new year starts, because you would still be able to use the no rehire clauses without falling under the applicability of this law. So just keep that in mind if you have any cases that are ongoing, cases that are pending, or matters or disputes that are pending. So there are some exceptions to this new ban on no rehire clauses. One such exception is the situation where you, as the employer, have a good faith belief that the employee engaged in sexual harassment or committed sexual assault. I can actually think of an example of a case this would apply to, and that we are currently handling, where a situation with a manager was accused of sexual harassment, and when the client conducted an internal investigation and formed a good faith belief that the manager engaged in that sexual harassment, they terminated the manager. The manager then turned around and sued the company for age discrimination and some other claims. In this situation, in this hypothetical situation, applying this new law, we would be clear in this situation to have had a no rehire clause in any severance or settlement agreement with this employee, because we had the good faith belief that the employee engaged in sexual harassment or committed sexual assaults after conducting a reasonable investigation. Another exception would be for legitimate, non-discriminatory, or retaliatory reasons for terminating employment or refusing to rehire an employee. This is a little bit unclear because the law does not necessarily provide any guidance on what constitutes a legitimate, non-discriminatory, or non-retaliatory reason. We do believe this is going to be played out in the courts, so stay tuned and we'll keep you posted. If you have any questions regarding how to move forward on a situation that involves these circumstances and you want to use a no rehire clause, feel free to reach out to us. We'd love to help you kind of think through it. So next, we have the statute of limitations under the FEHA, which is, as you know, the California's anti-discrimination statute. So under the new law, the statute of limitations will be extended. Just to give you an idea of where the law stands currently, the statute of limitations period for filing claims of discrimination, harassment, and or retaliation with the DFEH, which is the state agency for filing discrimination claims or complaints of discrimination or harassment or retaliation, is 1 year. So in an example, if an employee feels that they've been discriminated against for some reason, they have 1 year from the last act of discrimination to report it to the DFEH. That is now being extended to 3 years. That's potentially going to cause some problems for employers, as you can imagine, because there's going to be a significant amount of time now where an employee can kind of sit on a claim before filing it with the DFEH and then taking the next steps to file a lawsuit. So that, of course, means that there will be an increase in back pay damages because an employee will be literally sitting on this potential employment dispute for 3 years now, before having to take it to the DFEH, and then being given a right to sue letter to take that to a court of law and engage in a lawsuit. So important things to note here is that documents, emails, and witnesses are going to be critical. We need to save these to the extent that we can, because now, to give you an idea of what the universe of a claim under the DFEH, or a claim under discrimination or retaliation or harassment claim under the DFEH will look like, it could potentially be up to 4 years before someone actually takes an employment dispute to a court of law and an employer is served with a complaint. That means that a lot of the information, a lot of the witnesses that we're going to rely on to defend against these claims are either going to be no longer working for the company. We all know that people don't always work for companies forever, so people come and go. Documents get lost, especially if they're not managed in a correct way or not filed properly, and then it makes it very hard to track down when you have a lawsuit you're facing after an employee left your company 4 years ago. So it's important to try to maintain prudent record-keeping practices. Just so you know, California does have record-keeping requirements for various types of records. This is in line with, I believe, with a majority of the record-keeping requirements in California, which is 4 years. We need to keep everything regarding an employee's records for at least 4 years so that we can make sure that when they do come back with a, if they do, hoping they don't, come back with a lawsuit, we can adequately defend against it. So one idea that we'd like to provide as advice is it would help to, I guess, cut down on space and resources and costs if records are kept electronically. And it would also save some trees. So if you, to the extent that your operation can do it, saving trees and going electronic will be a lot easier for maintaining records like this so that we are able to defend against any claims that an employee brings nearly 4 years after leaving or after engaging in whatever employment dispute they're alleging was discriminatory, retaliatory, or harassment. I'm going to pass this over to Krista for SB 142.
Hello, everyone. So we have in California been dealing pretty much on an annual basis with like drips of updates to the lactation accommodation law here. And several years ago when we first had a lactation accommodation law enacted, it really mirrored federal law and was pretty easy to comply with. But we've now got a lot of very specific language in this law that really differentiates it from federal law, put several more burdens on California employers, and this really was kind of prompted by San Francisco's position on lactation accommodation. So here are the key changes to the new law that takes effect January 1st, 2020. First of all, I think we all know that we've got to provide a lactation room for women who wish to express breast milk at work, and that it needs to be private. But there's more. Starting January 1st, the room has to specifically be safe, clean, and free of toxic or hazardous materials. It has to have a surface where a woman can place a breast pump. It has to have electricity or some kind of setup so that a woman, like a battery pack, something, so that a woman can actually plug in said breast pump. There's got to be seating. Just chair is fine, but just a place to sit. And I know a lot of companies use a multi-purpose room, a quiet room, or a health room that can be used either for lactation or for other purposes. And that's fine. You can still do that, but under the new law, if you do that, lactation accommodation has to take priority over any other use. So if you have people using a room, to take breaks, to sit down, to make personal calls, that's okay, but you've got to figure out a system whereby it's used first for lactation. If a woman needs to use it for that break, she has to be able to use it, before anyone else uses it for anything else. Something else that is new is that you've got to provide access to a sink with running water and a refrigerator suitable for storing breast milk, which is close to the employee's workspace. A lot of this, the law changed last year to talk about the fact that, if it's a room other than the person's office, it's got to be not a bathroom and close to the person's normal workspace. And this law is really driving that home. It's, I think the underlying message is we don't want women to have to lose even more of the workday, walking across town to get to this room. So not only should the room itself be close to where she normally works, but the running water and the refrigerator where she stores her breast milk need to also be close to her workplace. This is really important. The new law requires a written lactation accommodation policy that specifically addresses all of the bullets I just shared with you. So it's basically got to reflect the specific elements of the law. The written policy also has to inform employees that if they feel that they have been denied lactation accommodations, they can file a claim with the Labor Commissioner's Office. And speaking of the Labor Commissioner's Office, another change, there wasn't really any kind of penalty in the past for violating the lactation accommodation law. Now there is. And the Labor Commissioner can issue a $100 per day fine for failure to provide lactation accommodations. Also, there's retaliation language in the statute, or I should say anti-retaliation language in the statute. So if a woman feels that she has been retaliated against or discriminated against for requesting lactation accommodations, that also would fall under this fine of $100 a day that could be recouped via the Labor Commissioner. Now, there is a hardship defense, which there has always been, but now it only applies to companies with 50 or fewer employees. That hardship, and let's see, I think I've got it here. Yeah. That hardship exemption used to be available to everyone. It no longer is. It's fairly hard to satisfy. You basically got to show significant difficulty or expense to seek an exemption from this law. And even if an exemption, there's a finding that, okay, this small company is exempt, you've still got to do your best to provide lactation accommodations. You might just be able to get out of, some of these very specific requirements. All right, I am next going to talk to you all about minimum wage. It's been going up every year, and that has not changed. So, starting January 1st, 2020, our minimum wage statewide is going to be $12 an hour for companies who have 25 or fewer employees, and $13 an hour for companies that have 26 or more employees. Now, as you all probably know, the really important thing about this is that it changes the minimum salary you can pay exempt employees in California. So that now means, and I've got this on the slide here, for small companies, 25 or fewer employees, the minimum salary for exempt employees starting January 1 is $49,920. For bigger companies, it's going to be $54,080. And the only other thing I want to mention here is there are almost 30 local minimum wage ordinances throughout the state. So if you live in a place where you think there might be a different minimum wage, reach out to us. We can help you figure out what it is. Or you can, go on your local government website. It should tell you what the minimum wage is there. Local ordinances do not affect the minimum salary to be paid exempt employees. That's governed by the state minimum wage, but the local ordinances will govern, the minimum hourly amount you are permitted to pay non-exempt employees. All right, I'm turning it over, I believe, to Kristina.
I think I'm taking the first two. So
or Caleb, sorry. Go ahead.
So let's see. Let's start with SB 778. We're just going to cover some additional laws here for you guys. For SB 778, the deadline for employers with 5 or more employees, and this includes seasonal and temporary workers, to provide sexual harassment training every 2 years, is extended to January 1st, 2021. The previous deadline was January 1st, 2020. I think this is a little bit of another little small victory we can claim, that employers are having a little more breathing room with regard to getting the trainings done for their employees, sexual harassment training done for their employees. A couple notes. So employees who received training in 2019 are good, and they've satisfied the requirements. There's no need for them to be retrained for this new extended time period. Also, the requirement that new employees or recently promoted employees must receive the training applicable to their position. They must receive the training applicable to their position within 6 months of starting the job. So if you have a new employee or an employee who's promoted to a supervisory role, or even an employee that was promoted within a non-supervisory role, they need to receive their sexual harassment training under this law within 6 months of starting the position. Just to give you guys a little bit of history, California enacted SB 1343 in September 2018, which extended the requirement that employers provide supervisory employees with 2 hours of anti-harassment training to businesses with 5 or more employees, including temporary or seasonal workers, from the previous threshold of employers with 50 or more employees. The 2018 law also expanded the training requirement, which previously applied only to supervisory employees, to include 1 hour of training every 2 years for all non-supervisory employees for covered employers. So just as a catch-all here, this deadline, again, is now extended to January 1st, 2021. So make sure you get your employees trained. If you have any questions with regard to sexual harassment trainings, we're always providing them here. Just let us know or shoot us an email. So the next law, AB 1223, under this law, employers must provide 30 days of unpaid leave to employees donating an organ, in addition to 30 days of paid leave currently required. So the existing law, the Michelle Macon Memorial Donation Protection Act, requires a private employer to permit an employee to take a leave of absence with pay, not exceeding 30 business days in a 1-year period for the purpose of organ donation. The existing law requires a public employer to permit a public employee to take a similar paid leave of absence for organ donation if the employee has exhausted all available sick leave. Now, with the passage of AB 1223, private and public employers must provide an additional 30 days of unpaid leave. And I'm going to pass it over to Kristina to handle the rest. Remaining two.
All right, next one is AB 203, and it has to do with a very not well-known fungal illness that people working in rural areas can contract, called valley fever. Fun fact, I've had valley fever. It's not fun. It causes fever, chest pains, coughing, and other fun symptoms. But under AB 203, construction employers are required to provide training regarding valley fever to employees working in areas affected by the disease. So affected areas under AB 203 are basically highly endemic areas, and that's defined as having annual incidence rates greater than 20 cases per 100,000 persons per year. These include, but not limited to, counties such as Fresno, Kern, Kings County, Madera, Merced, Monterey, San Joaquin, San Luis Obispo, Santa Barbara, Tulare, and Ventura. Basically, valley fever is a fungus that grows in soil and in high farm crop areas. So if you're an employer that's based in an area that's more rural, this law might apply to you, so just be aware of it. SB 83 extends paid family leave benefits provided by state disability insurance from 6 weeks to 8 weeks. It takes effect July 1st, 2020. And just as a reminder, employees are entitled to paid family leave to care for a seriously ill child, spouse, parent, grandparent, grandchild, sibling, or domestic partner, or to bond with a minor child within 1 year of the birth or placement of the child via foster care or adoption. And this was one of Governor Newsom's campaign promises, so no surprise here.
It's Krista here. It looks like we have several questions. Oh, Cam, do you want to run the questions? How do you want to do it?
Sure, I can run the questions. I can start by going through a few of the questions that relate to arbitration really quick. We received a lot of questions about whether the new law on arbitration, AB 51, which prohibits arbitration agreements in for FEHA matters after 2020, whether that would apply if you have an agreement that is entered now that gets extended into 2020, or if you just have an agreement that you're a new employee that you're hiring now, and that employee remains employed after 2020. There's been a lot of questions on that. And generally, technically speaking, the law only applies to contracts that are entered into, modified, or extended after January 1st, 2020. So if it was not entered into, if it was entered into before 2020, technically the law shouldn't apply. If it is modified after 2020, then it would apply. The question then becomes whether an employee that was employed and entered into the agreement prior to 2020, and then they remained employed after 2020, whether that employee could still claim that since they've continued their employment into 2020, whether AB 51 should apply to them. And that is unclear. Arguably, it should not apply because the contract was entered into prior to 2020 and it wasn't modified or directly extended because it was open-ended. But this issue is likely to be litigated, and it's highly likely that an employee that wants to get out of the arbitration clause would argue that it was an extension since they remain employed past 2020. But for the most part, I think employers could try to rest assured that if they reach an agreement with somebody prior to 2020, then that arbitration clause should be okay, and they could definitely argue that the misdemeanor clause of that provision should not apply. But it is possible that the arbitration clause could be invalidated by somebody that tries to argue that it was an extension by default because they remained employed. So we'll go on to another question that came up was whether AB 749, which relates to, one second, the no rehire clauses, whether that applies to all states or California only. And the answer to that is that it applies only to California. Nearly everything we've talked about here applies to only California employees or employees that work in California or reside in California for the most part. There's also been a question about whether these laws apply to public employers. As some of you may know, if you're a public employer, a lot of the labor code does not apply to public employers unless the labor code provision directly mentions that it does apply to public employers. We have not done an analysis of these new cases yet, of these new statutes, to see whether they directly mention any reference to public employers in them. But if you have that question, we are happy to answer it for you. We're going to look into it and get back to you by the end of the week. So if you have that question, please let us know, and we'll get back to you with that. Okay. Now
I can take the lactation accommodation questions if you'd like.
Sure. Yeah. Let me go ahead, Krista.
So it looks like there were several questions about application of the new lactation accommodation law, including what about agricultural employees, what about people who work from home, and what about outside salespeople. The law does specifically address agricultural employers and says that they shall be deemed to be in compliance with this law if the employer provides the employee wanting to express breast milk with a private, enclosed, and shaded space, including but not limited to an air-conditioned cab of a truck or tractor. So that is how this law is dealing with that scenario. It does not address like outside salespeople or employees who work from home. I think, you're pretty safe with employees who work from home. You may want to just confirm with the employee that they have in their home office a place to express breast milk, running water, fridge. I mean, that's something I would not be too concerned about, but you might want to clarify it. Outside salespeople, that is a great question. The law doesn't specifically address that scenario. And I think it really depends upon whether that person's normal workplace is a home office and they go out to sell from the home office, or like a company office space. If it's a company office space, then you're going to want to have a room there for the person to express breast milk, so that, in between sales calls, they would go to the office and do it. If it's their home, we just talked about the home. So that's really, what it's going to come down to in that situation, I think. I think that's it. Do we have any more questions, Cam?
There's a lot of other questions regarding paid family leave, and I don't know if we have enough time to get into them. What we'll do is get the remaining questions and send out an email to the group about those questions in case you're interested. That's basically it.
Lauren, you want to wrap us up?
Yes. Thank you, everyone. Thank you, everyone, for attending. And like Kamran said, we will follow up on those questions that we got right there at the end. And like I said at the beginning of the webinar, the recording will be available on Foley.com in the next couple of days. So just keep an eye out for that. Thanks, everyone.